Hi, this is Nicole Gonzalez Van Cleve, and I'm the author of the book Crook County, Racism and Injustice in America's Largest Criminal Court. With the release of this book, one of the things that I wanted to do is create a series of videos so that readers can engage deeper into some of the content of the book. I wanted to talk a little bit more about methods, analysis, theory, and actually the hope for reform. So what you'll find now is a series of videos that talks about everything from court watching, ethnography, some of the emotional difficulties creating and writing this book, as well as some of the things that make me very hopeful for reform in our criminal courts more specifically, and the criminal justice system more generally. So please use these videos to generate discussion in your classrooms amongst other policymakers, and let's start a dialogue to get to a better criminal justice system in America. So what is ethnography? So this book started as an ethnography that really was an inspiration from my undergraduate years. I was taking a class in field studies work, which allowed me to go and work in a field site for a long period of time, an entire semester. And I had dreams of being a lawyer, and so I wanted to work in the prosecutor's office. One of the things that I did was start to do deep field work or ethnography in the criminal court system. And so many people have asked me, well, were you there looking at issues of race or matters of racism? I mean, the truth is no. I actually told my subjects that I was studying culture, the organizations of courts, professionals, how lawyers practice law, and that was the truth. I think what was so shocking is that as I created that thick description, that ethnography of the prosecutor's office and then subsequently the public defender's office, what I noticed was acts of racism that were difficult to ignore. And so it was the coding of those incidents of racism, everything from racial slurs to the use of ebonics to the abuse of defendants, victims, and family members that started to, in some ways, force me as a researcher to reconcile what role was racism having in this field site. So one of the things that I discuss at length, and I hope that folks, after they read this book, will start to debate as well, was that when your subjects are doing things that seem, in some ways morally reprehensible, as an ethnographer, you have to think long and hard about what your role is. And I think one of the most difficult things as an ethnographer was that I was both part of this culture, but observing this culture. And I think that meant that I had to reconcile with some of the things that people were doing when they act in racist ways or did, laughed at racist jokes. As an ethnographer, your role is to participate. Your role is to, in some ways, immerse yourself in that culture and not be separate from it. And so I think those are the things that, I don't have there's no easy answer about the ethnographer's role in the field site. And I think one of the things I was trying to complicate and encourage other ethnographers or other students and researchers to think about is some of the moral issues that we all confront as we collect data. One of the questions that I get the most about the ethnographic process of researching this book was how my racial and gender identity affected my subjects. Now, one of the things that I talk about at length in the book, and I try to be as candid as possible, is that my identity as a light-skinned Chicana really affected how the mostly white prosecutors, judges, police officers, and public defenders saw me. So it is no surprise that I was in some ways passing as white. I think that gave me a level of privilege and access that, sometimes it's unsavory to talk about, but I think it is no mistake that if I was a darker skinned person of color, that perhaps people would have been more guarded in their responses. But for me, it felt very important to use that privileged access to then report on these issues of race and racism. Once I was racially passing myself and I realized that I was categorized as white in this space, it became really important to me for the interview portion of this study that the interviews should be done by white women. Now, this is where the intersection of race and gender come in play. I think as a young woman of color that was passing as white, I could tell that this mostly male-dominated office space had no shortage of men that wanted to kind of tell me how the world worked. And so playing on these gender categories in some ways gained me more access. So a lot of times, saying things like, wow, I don't understand that. Can you explain that more? there was, men wanted to talk more. And so, it's in some ways, some folks when presenting this find this, a little bit funny that you can kind of play into these gender roles. But I think, gender and race are real. And, we're all, sometimes they're liabilities and sometimes they're assets. And I think as understanding it from an ethnographic standpoint, understanding how my own racial identity, how my own gender identity, and even how my age as a younger person in the field affected how people were relating to me, about how open they wanted to be with me, I knew it was important that the interviews should be done by younger women who were white, and with a sample of mostly white attorneys. I wanted them to feel that they could be as candid as possible and not guarded. As I aged in the field, again, this study started when I was very young and ended when I was, say in my 30s. People were more suspect of me. People asked me, are you a reporter? Are you a professor? You're just, the public defenders would say, well, you're just going to write another negative, article about us and how incompetent we are. People were extremely suspect. And so again, I think to me, this was in some ways a case study of how age, gender, and race all in some ways intersect, and how if we're doing research, we need to really always be inventorying and being aware of how these identities are affecting our subjects and how they're affecting the candidness of their responses. So one of the things that's really difficult and inspired the methods or my methodological approach in this book was that, doing this research, I was doing it in a colorblind era, right? So in some ways, I am exploring how racism is practiced in a social space at a time where people do not want to talk about race. In fact, they are absolutely denying that race is operative in the work that they do. So how do you measure race? What I found was that there was not one approach that could really capture or see race in a colorblind era. So it started with an ethnography, which was in some ways looking at how people practiced race and racism in a social setting. So what role did race play in the disposing of cases in a criminal court, in some ways negotiating people's due process rights? What role did race play? And so to do that, I felt like I had to kind of practice alongside attorneys. And it wasn't just good enough to be on the prosecution side. I felt that you needed to have a fair picture of both sides. So the prosecution, thinking about how do they understand the court system from their point of view, and then switching sides and doing a completely different ethnography in the same court system of public defenders. So this gave me really rich data of how you practice within an institutional setting. But it didn't give me enough data on how people understood the work that they did, how people had ideological opinions about race, about justice, about their role as attorneys and judges in the system. And that's where interviews were extremely important. There was a large sample of interviews done with judges, prosecutors, public defenders, and private attorneys. And that was really an attempt to compare how do people actually practice the law, and then how do people actually think they practice law? What are the sincere fictions, if you will, that they tell themselves that help make their work make sense? And what you see sometimes in the book is that some people were in some ways expressing very tolerant racial views in one context, but they were doing particularly racist things in another context. So I found that the contrast between those two different types of data, both the ethnography of how people practiced and culturally understood their work, with how people kind of reflected and ideologically described their work, was really important. So the final element of data that I used was something I call court watching data. I actually came up with this idea of doing court watching, and it was inspired from kind of a criticism of early versions of this work. When people were asking me, is really race a thing in this space, or is it really class that's operative? Are we seeing racism, or are we seeing classism? So one of the things that I had to do was kind of, in some ways, test that. So how do you do that? Well, what I decided to do was a large-scale court watching data collection, where I in some ways was inspired by this idea of almost bringing in secret shoppers, if you will, into our court systems to evaluate how they were working. So, when we think about consumer institutions or retail spaces, people send, in some ways these secret shoppers to go in and test, what is the customer service like? And so in some ways I thought, well, why wouldn't we treat our court systems this exact same way? These are in some ways sacred spaces where people go to, to remedy these wrongs, very serious wrongs, or to have their rights protected. So shouldn't we uphold it to that same level of kind of consumer service? So what I did was I trained 130 research assistants of varying racial background, and rather than having them dress in suits and ties and look professional, if you will, like other lawyers, what I had them do was dress down, in some ways stripping them of their social class and allowing their racial identity just be part of the variable that's introduced in the study. They were given semi-structured forms to collect data, and it was through looking at their analysis and really comparing how white researchers and researchers of color were treated that you can really distill what role race was playing in that space. So all court watchers brought in 2 different forms into the courts. They brought in forms to watch short hearings like plea bargains and court call, which is just the everyday workings of the court, and pretty much anything that didn't involve a lengthy hearing or trial. They used a different form for trials and hearings that were kind of over, a few minutes long. And every court watcher went through a training session. So in some ways, they knew some of the basics of the court. So for instance, telling the court watchers, you're not going to see a lot of trials. 90% of cases are plea bargained. Or, giving them some, reasonable definitions of some of the abbreviations they may hear. But also then taking them through carefully the protocols and what they were observing. And finally, being an ethnographer, I wanted to show them that they could create thick descriptions about what they were seeing. Everything from the seemingly mundane tasks of going through security to seeing the standards of the water fountains and the bathrooms and the segregation of the people in the gallery of the court versus the, near the bench. I wanted them to, in some ways, turn on an ethnographic eye. I think some of the most unsettling parts were the researchers of color, they complained about being mistaken for defendants because the racial segregation in this court system was so intense that even if you had if you were a law student from the University of Chicago or Northwestern in DePaul, to be a person of color, to be black or to be Latino in this space meant that you were a defendant. And so when they dressed in sweatshirts and hoodies, they were mistaken for defendants. They found this extremely upsetting, as you can imagine. The other set of researchers of color were also ignored in some ways to the point of invisibility. So you almost had 2 key findings here, is that these researchers were either in some ways mistaken for defendants or they were invisible socially. And so that was extremely powerful. In terms of the white court watchers, how were they treated? Well, many of them said that it was almost impossible for them to gather data in this court system at times. They would walk into the court system and find it particularly difficult to actually seamlessly navigate the space because to be white in this court system meant that you were a professional, perhaps a journalist, but certainly you weren't from around here kind of thing. And so the presence of a white court watcher meant that you might in some ways infiltrate some accountability in the system. And so many of the white court watchers talked about being singled out, being in some ways treated in hostile ways by the judges if they were exposed to be court watchers. The other side of it was that they were given particular privileges. So that was the other kind of compliment, is that if they weren't treated hostilely as some kind of accountability, they were in some ways seen as privileged bystanders, if you will. And so the sheriffs in many cases took particular pride in escorting these white court watchers to particularly gruesome cases that kind of amplified this voyeuristic effect of whites gazing on the types of racial suffering that was happening. So I think it was, in some ways for me, I tried to create this kind of mixed qualitative approach, in some ways to kind of help us see race when it's in some ways difficult to talk about, difficult to observe, at least when I started doing this research. And it became even more difficult in this kind of era of Obama when people said, well, we're in this post-racial era. What could you possibly think about when talking about race and measuring race? Well, the answer came, if you will, both from the observations that I did, as well as the interviews of people reflecting on race and reflecting on their jobs, but then finally in that court watching data where you can actually tease out what was it about race and not class that made this a space where racism was operative and part of the system and its functioning. When we think about doing ethnographic research, most people don't talk as much about the emotional investment and the emotional toll that it takes. And I think in particular for scholars that study if they study, in some ways, folks that are marginalized, or for folks that are created in the condition of marginalization, which I talk about, I think it can be, there's a taxing part of this that I think is one of those things that people talk about, kind of in secret. They, talk about it in private with their friends, but they don't really acknowledge it up front. And one of the things that I wanted to do is start a dialogue about how difficult some of these studies, especially about criminal justice, are. I mean, day in and day out, it wasn't just the violence of the cases that sometimes came through the court system. I was in some ways emotionally prepared for that. I knew what I was getting into. I knew that being in a prosecutor's office, you would open up a file and maybe see photos of violence and the suffering of victims. What I didn't expect was to see the emotional abuse of defendants and their families and the victims themselves. And I think for me that was the toughest part of doing this study, when prosecutors were callously, in some ways, making fun of defendants, or making fun of defendants who were convicted and crying because they were losing their family or they couldn't see their young child. That was some of the things that really took a toll on me. And so I encourage ethnographers not to, in some ways, shy away from these issues. But I think one of the things that I'd like to do is start a dialogue about, how do we emotionally cope in the field? I think one of the things that I did was that, being at Northwestern at the time, Northwestern University, they had a women's center and they supplied counseling. And so it was certainly the case that I did have kind of these like flashbacks. I remember opening up a file and seeing a dead child, and those are the things that I, saying in the book Crook County, you can't unsee. You can't unsee that, and you can't unsee when the prosecutor is in some ways making light of that. I think that's a secondary type of trauma or emotional toll that this type of research takes. And so I think one of the things I try to do and introduce in the book is that ethnographers and researchers really take stock of the emotional toll it takes in your research. And in some ways, it's almost data itself. If you're seeing subjects being mistreated and you feel the emotional toll, understanding and writing about that in the field notes is enormously cathartic. It's enormously useful to taking stock and keeping emotionally healthy within the field. But it's also part of the data. When I was coming home so upset and having difficulty eating or sleeping, to me, it really amplified the findings that I was seeing. I was seeing grave racial abuse in a world that was somewhat colorblind still, where people didn't want to talk about race. And this was a space that was totally different from the social world that I existed in at Northwestern or just in everyday life. And so in some ways, the emotional experience itself was a finding. So in the conclusion of Crook County, I have what I hope is a call to action. So if you're reading this book and you're a student in the classroom, an undergraduate, a law student, a professor, and even if a policymaker or a reformer, and you're thinking, well, what can I do now? You've shown me these courts. Is there anything we can do to make things better? I really think that one thing we need to do is we need to put some accountability into the courts, which means we have to go there. So that means serving on juries, making sure that you're aware of judges that are elected in your jurisdiction. Those are kind of first steps, and of course, as a scholar, I want to explore those as well. But one thing that you can do right now is to actually go do court watching in your jurisdiction. When we actually conducted it as part of this research, what I didn't expect to think or see was that it added a level of accountability that judges and prosecutors just did not like. When they found a court watcher in their court, they treated them extremely hostile in many cases because it added an accountability level that they weren't used to having. And so it really occurred to me that this is a way that we can actually affect change. If you sent people into court systems across America, would they treat people or abuse people in the ways that I show in Crook County? And so one of the things that I provide is the court watching research instruments, which are very user-friendly, so that you can go where you are, whether it's in a classroom or whether you just want to do it for a reform project, etc., and actually go into the court system and have some way of actually, in some ways recording your observations. So there's two forms that I'm providing. One is a court call form, and that's a form that you can use when you actually go into a courtroom and you're just seeing hearings. Those hearings can be anything from plea bargains to status updates, but it's very important because The court call represents the heart of due process in America. Most cases are resolved vis-a-vis plea bargaining. And so when we expect to go see trials, we're in some ways missing how justice is served on an everyday basis for the majority, the large majority of defendants. So those forms ask you to rate everything from how the judge acted to whether the defense attorney had access to get to their clients in lockup, and really pushes you to think about what is the environment of the court. Can you hear the court proceedings? Are they accessible? How do they treat victims and family members? Does it in some ways pass the Supreme Court standard that says justice must satisfy the appearance of justice? And your interpretation of that as a citizen is extremely important. So as we go in and evaluate our courts as consumers, right, as the general public, our point of view is very important to that end. The second form is a hearing form, and that's for anything that's just longer than the court call. It could be a bench trial, a jury trial, or a motion, but you do not have to be sophisticated in knowing which one is which. Really, it's how does this hearing kind of play out in a professional way? Did the public defenders look as polished as the prosecutors? Did the prosecutors, in some ways prosecute as a team, but there was a public defender that was completely on their own and isolated? It really pushes you to think critically about what that trial, how that trial was conducted, and also, if you are a victim or a defendant, how would that trial look to you? Would that be your day in court, and would that in some ways pass that standard of how justice is supposed to be served? So I encourage you all, go to the courtrooms and the courthouses in your jurisdiction. I'd be happy to hear many of you report back via Twitter and other types of social media to tell me what you're finding in your area. And hopefully, if many of us do this, the court communities across the nation will start to act in more accountable ways.